understand that my learned friend or state is going to bring an application for the exclusion of certain evidence which forms part of applicant 4's application. So perhaps we can hear what the nature is of the application by the state, and then we'll deal with it.
You indicated, Mr. Kaba, that there was going to be an objection to applicant number 4's papers.
Thank you, Worship. That is indeed what we highlighted earlier on. Your Worship, we were fortunate to be given a copy prior to the affidavit being read on record. What we then picked up is that on the affidavit by applicant number 4, there are certain documents that are attached. The first one being emails from
My learned friend proceeds. Those emails have been removed from the application, so they do not form part of the application.
I raised an issue earlier on that there are documents. I'm now relating what I said earlier on about the documents.
Why are you objecting?
Why I'm objecting. When you reply, when Mr. Vormanas replies, he can say, yes, I've removed this one, or whatever the case may be. I stood up and said, I have difficulty with certain documents attached. So now I'm given an opportunity to address the court on those documents.
I follow you.
There were email communications from Mr. Gaba, that is myself, email, official email, to Ms. Gilling. And some of my colleagues at work. Not relating to the accused before court. And therefore, there was no need for myself, as the person who was generating that email, to include any of my colleagues before court, meaning Mr. Tele and Mr. Damini and Mr. Mlojwa and Mr. Volmans, in that email. In the exchange between ourselves, I find my emails in accused number 4's papers, whereas he was not a party to that conversation, which is concerning. I'm asking myself how, for starters, did they manage to get hold of the emails between myself and Ms. Gillen? Not relating to this matter, yes, to the matter in Eswatini, but they were excluded because that email was specifically for Ms. Gillen. It's an official communication between two parties. Excluding others for reasons known to those parties who are party to the communication. And it was meant to be kept in that fashion. Hence, we were shocked when I saw that my emails form part of accused number 4's application. Before the matter started, I went to Mr. Volmarans and Mr. Trader to inform them this is a problem. Hence, Mr. Volmarans is now indicating that they've removed it. But it has to be placed on the record, because I indicated earlier on my concern. The second difficulty relates to a charge sheet from another country, in particular the court of the District of Manzini, which is in Swaziland, or in the Kingdom of Eswatini. Purports to be the record of court proceedings in another country. My understanding is that Section 235 of the CPA indicates how court records can be presented in court. And it is jurisdictional in a sense that it applies in the Republic of South Africa. I'm here to understand as to on what basis a charge sheet or court record of another country forms part of these proceedings under which section. One might argue it is a public document. What also bothers us more, on the very same document, there are notes written. Someone was working with this document, making notes of this document, indicating certain things on this document. More like, Your Worship, that my learned colleague, Mr. Twega, gives me an affidavit and say, please can you analyze this? Then I will make notes in that affidavit, so that when he gets it back, he can understand what changes he must do. It's like that. Now you are given notes of whoever thought you can attack this document because of A, B, and C, and it's given to you. The notes are not removed. The notes are there. From, I don't know how many pages are there, of an indication of how you should look at them in the critical eye of whoever made these documents. Or rather, whoever made these notes on this document. It does change material the actual document that was handed in court. How would you tell, if the copy is not certified, that the document that is being handed in this court is the actual document that was handed in that court? Because this one now has got notes written on it. We don't know whether it's a magistrate who wrote on the paper or it's someone else, but from what I'm seeing, it appears that an attorney or whoever got this made reference to certain things in these documents, of which you should not have sight of that at all. But I'm still standing here not knowing who made the notes. Because this charge sheet is not certified. It is on those bases that we are of the view that these cannot be admitted in this court. Unless there's anything else you wish to. Just a second. May I approach my group? I'm also reminded by my partner that the document itself, the charge sheet itself, does not relate to any of these accused. It relates to other persons in that court.
In that court of Eswatini.
Of Eswatini. This morning I indicated to Mr. Tele, you are attaching in accused number 2's application a copy of a charge sheet which you indicated is YY2. I said, please attach the entire charge sheet because you are attaching a court record. You cannot attach a piecemeal of a court record. I was hoping he was going to do it, hence I am also standing to say we have indicated to him that we will attach the entire court record in our replying affidavit because you only took a few pages of the charge sheet. It is the matter that we postponed earlier on this morning, the charge sheet thereof. Therefore, it is on this basis that we are saying the rules of admissibility, even though we are in a bail application, but it does not mean it's willy-nilly. Because you typify a document. I will make an example. With applicant number 2, the last document before the others were attached, it was typified or typified as a letter from the councillor, Mr. Tindimani. It's got letterheads and everything. Then you know what you're talking about. You saying I'm attaching and I'm saying this is a charge sheet. If this is a charge sheet, it then must follow the rules of how a charge sheet must be admitted in court. More so of a country that is not under the provisions of Section 235 of the CPA. On those bases, therefore, there are inadmissible portions of Mr. Kwabini's bail application affidavit, and we request that those be removed. My learned friend, Mr. Vomaras, has indicated to me he has removed at least the emails referring to myself and Ms. Gilling. Though we're still concerned about it, but we'll deal with it as the application goes on. Those will be my submissions, unless there's anything else that my worship like to be addressed.
No, there's nothing that I want to hear from you. My concern is, how did Mr. Volmarans or Mr. Taylor get hold of the emails between yourself and Ms. Gilling?
I have no idea.
Thank you, Mr.
Thank you.
Mr. Volmarans.
Thank you.
As has been pointed out, those emails have been taken out of the application.
But what was the purpose thereof in the first place?
Your Worship,
Emails that pertain to other parties other than your client.
it pertains to a matter which my instructing attorney is the instructing attorney in the matter in Eswatini.
So how do they relate to this matter?
Your Worship, I can't explain that.
In reply, Your Worship, this also complicates things further. Yesterday, I received an email from Ms. Gilling. After I have inquired from her, from our informal discussions, where I indicated to her, we do not know as the state in South Africa or the DPP's office in South Africa, in Durban in particular, as to who represent the two Eswatini people who have been arrested. I received an email with power of attorneys signed for Ms. Gilling saying I'm representing those two in Eswatini. Yesterday. Now I'm informed Mr. Tele is representing them, hence we got this document. It baffles me more and more as we go on. But the difficulty about this document, Your Worship, is this one little thing. It purports to be a charge sheet from another country. It purports to be a court record from another country. The authority for the admission of a court record is Section 235 of the Criminal Procedure Act of South Africa. It's not even stamped, it's not even certified to say what it purports to be. It is what it purports to be. I made an example of the councillor. We have a letterhead that says this is the office of Councillor Ndibande. What are these documents? How do we know this is the charge sheet from Eswatini? If there's no back of the court stamp to say that, I can understand the submission that everybody here has got a copy. The media people have got a copy. I don't have a problem with that. Having a copy and submitting a copy for evidence are two different things. For purposes of these court proceedings, whatever you have, it must be relevant and it must at least, according to the rules of evidence, as relaxed as they are, the problem you are having is you are submitting what you term to be a charge sheet. And you want the court to put weight on it as being a court record. From where? We don't know. Anyone can type this first page. We're not hiding anything. The papers that the DPP sent to Eswatini, we know what we wrote in. We're not hiding anything. All we're saying is, prove the documents in the manner that are supposed to be proved. Otherwise, if you can't, they cannot be accepted. It's as simple as that. Those will be our submissions.
They are challenging the evidence you're about to present.
I beg
They
your
know Mr. Volmaran's words, by the charge sheet, we are challenging the evidence the state is about to present.
How do they even know?
Those
How
were,
do they even know?
that was his submission.
Unless you can read from the crystal ball. For starters, just for starters, we might even choose not to lead an evidence. For starters, I do not understand on what basis can he make that submission. They haven't seen our papers. We have not even given them a draft. The understanding was, after the affidavits have been read on record, we will then reply. We're busy with our draft. Only that few of us knows what to contain there. He might anticipate. He might anticipate what he thinks. And what makes it even worse, the papers that purpose to be in this charge sheet are not all the papers we sent to them. For Mr. Volmaras to say it relates to this matter, it does not relate to this matter only, which makes it difficult now to bring evidence in a piecemeal fashion, because it does not give the proper picture that was given to a Manzini District Court. It was indicated right from the beginning, after the state has filed its affidavit, they will be given an opportunity to reply. Therefore, wait and see what has been filed and then respond, and not anticipate what you think is going to be filed. Because it might be different, you might be surprised. There might be anything at all. Therefore, wait. If you want to use this, in all fairness, follow the rules. Then you reply whatever you want to. It's irrelevant, as I said earlier on. Secondly, we don't know what this document is. Those are the submissions.
My ruling.
Oh, another aspect that Mr. Volmaras did not address, my apologization. There are notes here written on this document. It worries me. There are notes, and if the court sees that, I don't know what suggestion whoever wrote the notes wanted the person reading it to think of. The contents are typed, but they are handwritten notes in this very same document. I have no idea who wrote it, whether it's the magistrate who wrote it or somebody else wrote it, I don't know. Because there's a copy attached to this document where there are no handwritten notes. There's another copy attached where there are handwritten notes, which confuses me at all. As to what was the intention to submit and attach those papers that have no written hand notes and also attach the same papers with written hand notes. I have no idea.
My ruling is that I refuse to see the charge sheet from Eswazini. They may be relevant, maybe, I say may be relevant, but I see no relevance at this point in time of Eswatini charge sheet, and I refuse to see them. And moreover, I appeal to all the court officials to adhere to the rules of fair play. This is a bail application, I agree, but the rules of evidence are applicable, and I appeal that we adhere to the rules of evidence and commit ourselves to a fair play. Thank you.
Other court cases.
Just in response to one thing, what my learned friend, first he said it wasn't relevant, now he says it is relevant to this case, but be that as it may, Your Worship. The affidavit, of course, has to be reworked in order to remove the charge sheet and the offending documents. So, and I notice, Your Worship, that it's already 20 to 1, and I've been informed, I don't know whether correctly or incorrectly, that the court is going to adjourn at 1 o'clock because there's no water in the building.
I don't know. Nobody has informed me.
My learned friend indicates that that is the case, Your Worship. So perhaps we can roll the matter until tomorrow as set down.
Is that the position?
About the issue that there's no water in the building. I therefore take Mr. Wolmaral's submission that we roll the matter until tomorrow.
Mr.
And yes, the court pleases. Your Worship, though the record reflects that applicant number 5 was supposed to be also moving his application today in the light of the challenges that have been indicated, including, among others, the issue of the water in the building. I'm of the view that the same with applicant number 5, we can be able to proceed with this application tomorrow.
I want to place on record that I'm a little bit perturbed about the manner or the pace at which this bail application is proceeding. Bail application is supposed to be urgent, but with all respect due to the defense, there has been a delay of 2 days now due to unreadiness of the defense. I'm just placing that on record that it is disturbing on my part. But seeing that it is by agreement and due to circumstances beyond anybody's control, that the matter should be postponed until tomorrow, which was one of the days that it was set down for, the 18th, I therefore order that the matter shall then be postponed. Applicants may rise. Matter against you is rolled over until tomorrow, the 19th of March, for further evidence. You will all be kept in custody, Westville Correctional Institution.